A phoenix relates to a UK limited company where that company has entered liquidation, and then pretty much the next day the same or similar business springs up, and to an outsider it looks like it's exactly the same business because it's trading perhaps from the same premises, it's using the same staff, got the same directors, same assets, and this can actually look quite unfair to the creditors. However, it can be perfectly legal if it's managed in the correct way. There are some practicalities that directors will obviously need to consider if they're going to set up a new company, new co, to deal with the Phoenix, and see my separate video about those practicalities. What I want to discuss in this video is just to briefly touch upon the law, which says that a director of a liquidated company cannot be a director of another limited company with the same or similar name within 5 years, unless certain exemptions apply. And so there are 3 exemptions. The first one says that that new co has already been using that same or similar name for the previous 12 months, which is unlikely. The second is that the directors of the new co have applied to court for an order getting permission basically to use that same or similar name. This is probably going to be more problematical because it's going to take time, it's going to involve solicitors and applications and court hearings. And I very recently heard that the current cost for doing this falling at about the £7,500 mark. So probably not really the most convenient option for directors to use. And the third option is where the new co has purchased the assets at market value off the liquidator / the old liquidated company, and also has advertised and given creditors notice of their intention to reuse the same or similar name. Have to give 28 days notice of this. So there are some potential issues there. They have to think about that timing very carefully.
If you're a director and you're thinking about reusing the same or similar name of your old company, your liquidated company, ask yourself this: do you really want or need that name? Does it actually have any goodwill or value to it? Because obviously the old company is going to be liquidated, and so that name may actually be now attracted with bad will. And so I don't always think it's worth it. You've got all these exemptions and hurdles to think about. Sometimes it's just easier to completely wipe the slate clean and start off with a brand new, shiny, different name and remove yourself from any connection with that old liquidated company.
So Phoenix can be possible, but lots of practical hurdles for the directors to overcome. And if you really want to look into it in detail, then you need to look at Section 216 of the Insolvency Act 1986 and the Insolvency Rules 22.4 to 22.6 of the Insolvency Rules England and Wales 2016.